So the title of my talk, not as it is written here, it's changed a little bit. It's called Limited Spheres versus Limited Capacities, Two Models of Judicial Role in Emergencies. And before I start, I just want to thank Ido and Michal for organizing, inviting me to the Minerva Center for holding this, and Gad for being here and responding, and too, thank you very much. So, the paper I want to present here today is a very rough first draft or sketch of a work in progress on the institutional role of judges in emergencies. I will use, ultimately in this project, a set of historical US Supreme Court decisions to distinguish and categorize two types of arguments made by judges about their limited role in deciding emergency and security cases. One set of arguments is a classic separation of powers account that justifies deference to government decisions by demarcating spheres for judicial, executive, and legislative supremacy. And I claim that this type of argument often masks both an expansion and an abdication of jurisdiction. Marking spheres for judicial rather than executive or legislative authority creates opportunities for judges to act unconstrained as long as they stay within their sphere. At the same time, it legitimizes other branches' expansion as long as they stay out of the judicial sphere. The second approach envisions a different landscape, a shared and open terrain of limited capacity. Here, judges see themselves as limited, not because they are spatially confined, but because the constitutional system in emergencies operates under conditions of uncertainty and therefore under the general assumption of limited capacity. When judges operate under such assumption, I claim, they may acknowledge and support the creation of more flexible and diverse institutional tools to ensure both accountability and efficiency in responding to emergencies. Put another way, if they can't act as all-powerful rights protectors, judges may make space for more rule of law furniture, which are sophisticated institutional inventions to achieve accountability under conditions of limited capacity. So I will first present the claim about why we need to distinguish between the two models, and then I'll try to illustrate it briefly using a British 2004 House of Lords plurality opinion on Article 15 ECHR derogation measures. As I said, ultimately this project will focus on US Supreme Court cases, but for now I use the UK derogation case for inspiration and for illustration purposes only. But before I start, just a note about the background to my approach. So the starting point for this research project is my 2016 book on emergency powers in public law, which was published by Cambridge and was the culmination of my doctoral project at NYU. The book challenges the background theory of emergency powers, which centers on the paradigmatic and dramatic problem of exception, and shows, using case studies, how the focus on the exception, on exceptional events, exceptional time, exceptional measures by an exceptional responder, and so on, obscures and overshadows the wide range of practical and theoretical issues that are critically important for the daily legal management of emergencies. Rather than the limit of law, the book finally claims emergencies tend to be areas of law production, mobilization, and institution making. And therefore, the book suggests a move from the exception to a process-based approach to emergencies in public law. Importantly, however, the book didn't deal much with the judicial role or with classic questions of judicial deference to the executive in times of emergencies. Real-time institutional environments of response in the modern administrative state and in international realms, I claimed, are much richer than the institutional framework envisioned by the classic division of the powers between executive, the legislature, and the judiciary. And I illustrated the claim in a chapter on authorization to respond to emergencies, where I compared two small but influential legal agencies operating within the US executive and the UK Parliament, and I showed how their placement within their respective constitutional system, rather than the assumed centralization of powers in the executive, implicated their institutional traits, functional, professional, and ideological, and therefore their capabilities as responders in post 9/11 legal reform. Now, in this project, I aim to turn to look at the role of judges and the problem of deference in emergencies, but again, I do so under an institutional process approach. So a little bit about the institutional process approach as it regards rights protection. So in 2004, Samuel Zakharov and Richard Bild published an influential article titled "Between Civil Libertarianism and Executive Unilateralism, an Institutional Process Approach to Rights During Wartime." Building on empirical analysis of American court cases and security decisions, they claimed that in heightened times of national strife, the judicial role was always and should be not to protect individual rights, nor to defer to executive unilateral decisions, but to maintain a broad-based institutional structure of political accountability for actions taken in the name of national security. Now, the value of this approach was twofold. First, it moved away from the polarized assertions between, on the one side, executive unilateralist realists, as they call them, who claim that the executive possess emergency response capabilities that are unmatched by any other branch and therefore should hold unrestrained discretion in times of emergency. And on the other side, civil libertarian idealists, as they call them, who insist that courts can and should protect individual rights from emergency time executive abuse. Instead, Zakharov and Pilz proposed a model that stresses the preservation of political incentives within a system of separated powers aimed at enhancing democratic accountability. Now, another value of their approach was that it reoriented the heavily theoretical debates about emergency law to an empirical investigation and to the real experiences of constitutional democracy during crisis. Historically, Zakharov and Pilz claimed courts in the US maintain scrutiny during times of crisis, not by upholding first-order issues such as rights protection, but by taking on second-order issues such as the appropriate institutions and processes through which decision-making on security matters should take place. Now, acknowledging that the institutional process approach is today dominant in American legal and political theory of emergency powers, my paper focuses on its limits. While it stands for a realistic and methodologically sustainable approach to emergency jurisprudence, the danger of the institutional approach, I claim, is its limited conception of institutional roles, and in particular of the role of courts in emergencies. The same historical material that Zakharov and Pilz used to show the adherence of US courts to the democracy-enhancing constitutional principle of separation of powers, in fact, show the opposite, a deep failure of political accountability. Often judges' assertions of their own limited role in emergency serve to mask the self-authorized expansion of the proclaimed judicial sphere and to legitimize efforts by all branches of government to avoid accountability. To respond to this failure, the paper suggests a distinction between two conceptions of institutional role as they appear in US courts' second-order reasoning on security matters. The first is a dogmatic delineation of institutional role, which assumes that each branch of government is supreme in its own sphere. This conception of institutional role as technically contained within spheres allows courts to monopolize their own role as rights protectors while seeming deferent to government emergency decisions. At the same time, it serves to legitimize other branches seeking to avoid scrutiny as long as they stay within their sphere. The second conception of institutional role is more nuanced and promising. Here, judges acknowledge their personal limited capacity. Just like all other officials working within a rule of law state, they must be careful not to act as all-powerful, all-capable response actors, especially when operating under conditions of uncertainty. Instead of imagining a sphere of monopolized authority, the judge under this model envisions an open, linked, and shared institutional environment of emergency response. This is where David Eisenhow's idea of the rule of law furniture may come into play. When judges, as well as other institutional actors in a rule of law state, operate under the assumption of a limited role within an open and linked rather than a sphere-divided system, they may acknowledge and foster the creation of other institutional arrangements that will make accountability probable under conditions of limited institutional capacity. So I'll now briefly use the 2004 UK House of Lords decision in Belmarsh to begin to illustrate this typology and its possible implications. So in December 2004, the House of Lords issued its ruling in the case of AV, Secretary of State for the Home Department, known as the Belmarsh case. And in this case, the court declared that Section 23 of the Anti-Terrorism, Crime and Security Act 2001, introducing indefinite detention without charge to suspected international terrorists, was incompatible with ECHR right to liberty under Article 5 ECHR because it was decided to be not strictly required within the meaning of Article 15 ECHR Emergency Derogation Scheme. Now, many commentators regarded the decision as remarkable, as an outstanding landmark, a beacon of light, a victory to the rule of law. But at the same time, it was regarded as unstable, even schizophrenic, because of the gap it manifested between the court's full deference to government discretion on the question whether there is a public emergency threatening the life of the nation, according to Article 15 ECHR, and the court's full scrutiny on the question of the proportionality of the measures taken. Those were detention without trial of suspected international terrorists who cannot, for legal or practical reasons, be deported from the UK. It is worthwhile to stress the source of the gap or the instability. The government claimed that decisions on emergency, as a general matter, are subject to exclusive government discretion and that courts must differ on all matters of emergency. To resist this claim, the court made use of Article 15 framework to distinguish between, on the one hand, the question of determining the existence of a public emergency, on which it agreed government has absolute knowledge and authority and courts must differ, and on the other, the question of the proportionality of response measures, on which the judges are particularly competent. By strictly scrutinizing these measures, it had succeeded in holding the government to account in this area of political discretion. In fact, in the paper I show how broad and expansionist the court allows itself to be on the question of proportionality. However, by justifying exclusive government discretion on the question of the existence of the emergency, the court in fact provided particularly narrow answers to two questions that it wished to avoid. One, what is an emergency according to Article 15? And second, how it is to be identified. If the decision on the emergency is beyond scrutiny, then one, an emergency is that which the executive declares as an emergency, and two, the executive holds an exclusive authority to identify the threat and to declare the emergency. The implications of narrowing down the complicated problems of defining emergencies to a single answer is that alternative views and contestations, both on the problem of defining an emergency and on the process of identifying its existence, are obscured. There is, in this case, a rich terrain of alternative and competing definitions to what is the nature of a public emergency, an abundance of alternative descriptions of the existing threat as an emergency, a wide range of suggested methods for identifying the scope and the intensity of threats, Alternative claims regarding the proper process, procedures, and standards for identifying threats and the scope of the relevant evidence required. Alternative suggestions regarding the persons, institutions, and locations that are to be involved in such process, the conditions under which the process is to take place, and the time and place for contestation. All these are obscured by the court's somewhat anxious attempt to reject the government's claim that it is supreme over all emergency matters and that the court must defer on both questions. Now, interestingly, the Belmarsh plurality expressed a number of different accounts of deference to government discretion, and this is where I want to draw inspiration for the distinction that I made. So the most visible perspective on the meaning of deference is Lord Bingham's distinction in the majority between political issues that have to do with predicting the unpredictable as opposed to issues that are essentially legal. Under this depiction, deference exists on a continuum. The more purely political the question is, the more appropriate it would be for political resolution and the less likely it is to be an appropriate matter for judicial decision. I quote Lord Bingham in paragraph 29. Conversely, he says, the greater the legal content of any issue, the greater the potential role of courts, because under our constitution and subject to sovereign power, to the sovereign power of parliament, it is the function of the courts and not the political bodies to resolve legal questions. This demarcation of functions, or as he calls it, relative institutional competence, raises the question, how do we know that a matter is political? So many legal decisions have to do with unexpected future behavior of people. For Lord Bingham, it is the uncertainty that is inherent to emergencies that makes the decision on the existence of the emergency so essentially political and not appropriately under the responsibility of judges. But here he does not differ much from the government's claim that everything about the emergency, both its identification and what is needed to confront it, are inherently unexpected and risky. So ultimately, what seems to distinguish Bingham's notion of deference from the government's one is the discretion that courts have in demarcating their deference zones on the basis of their interpretation of the roles and responsibilities of judges. According to Bingham, the traditional Westbury approach to judicial review affords inadequate protection, he says in paragraph 40. It is now recognized under Convention jurisprudence and Human Rights Act jurisprudence alike that courts cannot abdicate their role as guardians of human rights. That's what it is. So this demarcation makes it possible for the court to hold both that the national security reasons are under the province of the executive and hold its own strict scrutiny of such reasons in its own sphere. And as we saw, this approach gives the court the power to demarcate the borders between spheres and therefore to expand their role on the one hand and overlook critical legal procedural issues on the other. Now, an interesting perspective on deference can be learned from Lord Hope's proposal in the same decision on a contextual standard of deference. The context here is not only the nature of the right to freedom, but also the context of the nature of the emergency. He says, imminent emergencies arouse fear, and as has often been said, fear is democracy's worst enemy. So it would be dangerous to ignore the context in which the judgment is to be exercised. Its exercise needs to be watched very carefully if it is preliminary to the invoking of emergency powers, especially if they involve actions which are incompatible with conventional rights. He then goes on to determine that the exigency of terrorism is indeed an emergency, but not one which is raised to the level of imminence required by Article 15 in order to justify such measures as discriminatory and disproportionate ones chosen by the government. The question for him is, do the exigencies of the situation determine that they're determining that if they're not imminent nor they are temporary, require that the appellants be deprived of the right to liberty. He claims that all factual material which may provide an answer to this question is in the hands of the Home Secretary, but he asks, has he asked himself the right question in his analysis of the material? So deference, according to Lord Hope, requires that the government asks the right question, and the right question is one which calls for a contextual analysis, which takes seriously both the context of rights and the context of the exigency. Yeah. But the most important, interesting, in my mind, account of deference in this case is Baroness Hale's notion of personal limitation. Baroness Hale says, it would be meaningless if we could only rubber stamp what the Home Secretary and Parliament have done. But any sensible court, like any sensible person, recognizes the limits of its expertise. Assessing the strength of a general threat to the life of a nation is, or should be, within the expertise of the government and its advisors. They may, as recent events have shown, not always get it right, but courts too don't always get it right. It would be very surprising, she says, if courts were better able to make the sort of judgment than the government. I, for one, would not feel qualified or even inclined to disagree. Now, on the face of it, this is in line with a strict deference approach. The government is best placed to identify and declare the emergency. Courts hold no expertise and can only intervene when it is patently clear that there is no such a thing. But there is a personal and somewhat hesitant tone here, which makes the demarcation less adjudicative. Baroness Hale is conveying her own imperfection and levels the government and the court's vulnerability to making mistakes. This does not, of course, solve the problem of gap between what the court can say about the exigencies and what it can say about the way to handle them. But by expressing self-doubts and limited capability and describing the possibility that courts would be able to say more than the government about the nature of this and the scope of the threat as a surprise, Baroness Hale provides a way to think her assertions wrong. The process of detecting an emergency, she reminds us, is a human process, a question of regular capabilities and regular failures. It therefore cannot be correctly in the province of an all-knowing body who decides. The problem with the government's strict deference, as well as the majority's functional deference, is that identifying an emergency is a complex process which may involve many voices and perspectives. The majority's finding that this process is inherently the government's business serves to legally obscure their relevance and importance. And so the process of identifying threat is seen to be a contested matter. How informed should that process be? What level of evidence is required and how should it be made available? And to whom? What is the court's role in assuring an informed process? What kind of standards of knowledge and expertise should be applied to the process and to its review? How should we understand threat identification as a local capability? And if deference is the standard of review over such process, how should we understand the term deference? As a functional division of labor, as a strict rule, as a recognition of complexity and plurality of voices in the process? And if so, how does this feed back to the procedural requirement that should be put in place to assure that contestation will be possible? This broad set of questions may empower judges as they acknowledge their own limited capacity to envision an alternative, broader and more flexible institutional landscape of legal response. And I finish by asking the question that is now in front of me, how to outline the value of a limited capacity model for the judicial emergency role in acknowledging and nurturing institutional space to entertain and take seriously questions that may have traditionally been characterized as outside the judicial sphere. Baroness Hale's depiction of an imperfect system prone to response failures may be a fruitful starting point for a new theory of the judicial role in an environment of limited institutional capacity.
experimentation. Because they will not serve us food and they're up to the need that you have really 5 minutes response and get that. I mean, against the food. Yeah. So thanks very much. It's a topic on which I've published and others have published as well, and I try to be very brief. So Karin is asking a very important question. This is a very important project, obviously. Why courts and justices or judges inclined to defer issues of national security? Now, you are focusing primarily on the issue of identifying emergencies. I would like to relate quite very, very briefly, kind of in a nutshell, to the whole issue of limitations of judges or justices in preserving human rights under conditions of belligerencies, warfare, etc. Actually, let me begin with an Israeli example, and this is based on a new research which we are going to send to publication in a few weeks. I will send you the draft in which we have scrutinized about 9,000 Israeli court rulings, and we have also a section about national security litigation. The probability is a statistical probability of an appeal which is relating to national security issues or against which the government is arguing national security to be dismissed by the court is 300 times larger than, let's say, appeals on issues of religious matters, which means that courts, as you have said very eloquently, inclined to defer issues relating to national security. We also have comparative literature about it. I would refer to an APSR article from 1995, Mishler and Shihan, which are relating to the American experience, showing very clearly that courts inclined to be fair, courts inclined to be very passive regarding issues of national security. And as you know well, there is also tons of literature about Israel in the occupied territories, like the book by Kretschmer on a similar issue. So the big question is why? And I think that in your paper, the why question in a way is still kind of anxious to be unveiled. You inclined to give examples from a few court rulings in England, but I have a sense that you still have to do more work on the question of why. Why courts inclined to defer this issue? So I will only, in a kind of a grocery list, would give a few answers, and I will send you some stuff about it, and then I would say what is my own opinion about the whole issue of national security matters and courts. And I'm much more pessimistic than you are about the whole future of the project. So first of all, judges, look at Hamdi versus Rumsfeld in the US. Courts inclined to identify with the nation state. You can call it patriotism, you can call it loyalty to the nation state. Courts don't incline to intervene in national security matters by and large, and including they don't incline to intervene with discussion about identifying a national security crisis. Second issue that you are developing in your own paper is the whole issue of fear and lack of security. There are many Obiter and other cultural in the Israeli case, including the famous case of unification of Palestinian families, which is not clearly a national security issue. But national security argument has become the main issue at stake. Faultily enough, however, it was the issue. And justices or judges are admitting that they don't feel secure enough or informative enough to deal with issues of national security. Let alone, and this is a different issue, there is not really equality between litigants in court. The state, let it be Israel or the United States or England, are coming to the court with most of the information. Often the national security establishment would have very organized data set which the appellant would not enjoy. And in your paper, you in a way, you are a bit oblivious about it. I mean, there is not, those of us who made some litigation in court, there is not really an equality in court. You can't really compare the state, the government, to an appellant. And this is certainly a factor in the final court ruling. Yes, so, okay. So only 1 or 2 minutes. So last and not least, this is, I think, a major theoretical issue. And here we may have a controversy. I don't think that national courts is a place to really challenge state power in cases of national security, for many reasons. I mean, it would take time to develop it. So I would argue that maybe instead of focusing on courts as a source of remedy in cases of national security, we may shift the view and look into social movements, media pressure, and those sorts of aspects of the civil society. Sure. But it's an excellent project.
This is really helpful. Thank you so much. I just want to say that my sense from reading is not to deal with this. That this is the first time to really deal with the agency of judges, as opposed to other institutions that I've been checking my previous work. Is that courts, although they do, and they feel themselves as the state, they try to contain the threat, which means the threat to the rule of law as well. So they try to explain or they try to make whole the political real with the legal one. And this is one big this is what they do for that. That's the way that efforts work. They don't really differ in the way that you do everything. No, we'll explain it all and we'll make it work in a way that will both justify the project, the national project, and our own placement, right? And so this project tries to see if there's also other kinds of intuitions of judges that are more sensitive to actually those places in society and in the institutional structure of responding to emergencies, the larger one, that would be beneficial. So also to civil society organizations, to rule of law, for example. So parliamentary committees, media, but judges can do a lot in also just a little bit of scrutiny. It doesn't have to be, it actually shouldn't be such an expansionist perspective over their role in the politics. But if they understand their own limited capacity within a broader institutional space in which capacity is limited and therefore should be expanded in an unconventional way into places where capacity is in existence, right, but not traditional places, it should be a good thing. So the attempt is to see where judges can take this. Not that, yeah.
Thank you very much.
lunch is served downstairs, floor 1. We will reconvene at 3:15.
We eat downstairs.